Welcome back to Two Cents Unfiltered. I'm Carrie. Today we're tackling a hard but necessary subject: why calls for political violence and the acts that follow must be met quickly and decisively by our attorneys general and law enforcement. This isn't about politics, it's about rule of law, public safety, and preserving democracy itself. Stick around, we'll cover the legal test for when speech becomes crime, real cases and consequences, why delay or leniency is dangerous, and what officials must do differently. Let's get into it. What we mean by political violence. First, definitions. When I say political violence, I'm talking about violent acts or credible attempts and coordinated plans intended to intimidate, coerce, or influence political actors, institutions, or the public. That covers everything from credible threats and assassination attempts to coordinated assaults on government institutions or property, arson of political targets, and organized conspiracies to stop governmental functions. Why the definition matters. Not all heated political speech is criminal. The U.S. protects a wide range of speech under the First Amendment, but there's a bright, critical line where words and planning cross into violent crime. That's the line we must detect and act on. Legally, the Supreme Court long ago set the standard for when advocacy becomes punishable incitement, speech that is directed to inciting or producing imminent lawless action and is likely to produce such action. That test, Brandenburg versus Ohio, gives us a framework to separate protected rhetoric from criminal incitement. It's strict, and rightly so, but it's not a shield for people who organize or intentionally spur imminent violence. So, when a political actor tells a crowd to do something in the heat of the moment, context and imminence matter, and when they supply logistics or mobs formed to carry out the act, that's where criminal statutes apply. The scale of modern political violence and why it's different. We are living in a new era of political violence and radicalized criminality, where once violent political actors were rarer and more localized, now we have sophisticated networks, online radicalization funnels, encrypted planning, and small groups willing to commit mass violence. Over the last few years, we've seen attempts on governors' residences, threats against elected officials, and politically motivated attacks that could have produced far worse outcomes. A political arson and assassination attempt is not just a headline, it's an existential threat to the safety of public servants and civilians. Legal tools and federal definitions. Folks often ask, what can prosecutors actually charge people with? The federal legal architecture includes statutes for violent crimes, conspiracy, weapons offenses, terrorism-related statutes, and specialized charges like seditious conspiracy. At the federal level, domestic terrorism is defined by statute and administrative guidance as violent, ideologically motivated acts intended to intimidate or coerce the civilian population or influence government policy. That definition guides intelligence, investigation, and prosecution priorities. State attorneys, general, also have powerful tools. They can use state-level terrorism statutes, arson and assault charges, and hate crime enhancements, or bring racketeering, conspiracy, or organized crime charges depending on the facts. Together, federal and state authorities can coordinate a layered, multi-jurisdictional approach, and they must. Case studies, when quick and harsh action mattered. Let's look at examples that show both the danger and the consequence of decisive action. 1. Seditious conspiracy convictions stemming from January 6th, prosecutions put leaders and organizers behind bars for years. The convictions of members of organized groups sent a clear message about the seriousness of coordinating violence to obstruct government functions. 2. More recently, prosecutors pursued an individual who attempted arson at a governor's mansion, an attack that could easily have killed civilians. That person pleaded guilty and faces decades behind bars. That's harsh, and it's necessary to deter copycats and to protect families and officials in their homes. When prosecutors move quickly and secure convictions in high-profile, politically motivated crimes, they remove violent actors from circulation and discourage others. That is prevention, too. Why delay or leniency is dangerous. Why not wait? Why not let things cool or treat these acts as political theater? Because delay has real costs. Delay allows networks to regroup and radicalize others. It gives violent actors time to refine tactics, to collect weapons, and to organize again. The internet is a force multiplier. A delayed response to an early attack can mean dozens more attacks later. Leniency sends a signal, and signals matter. When the legal system appears reluctant to punish politically motivated violence, it lowers the perceived cost for future attackers and damages public trust. Law enforcement must be seen as fair, firm, and impartial. That's the only way the public will trust criminal law to handle political violence rather than vigilantism. Now, I'm not promoting vengeance. I'm advocating for lawful, timely enforcement. The law must be enforced within constitutional guardrails with proper evidence and due process, but it must be enforced. The politics of enforcement, independence, and credibility. One reason enforcement sometimes hesitates is political pressure. Prosecutors and law enforcement can end up entangled in partisan fights about which targets deserve harsh treatment. That's lethal to legitimacy. Attorney generals, both state and federal, must demonstrate independence and consistent standards. They should apply criminal law based on conduct and threat, not ideology or political convenience. When attorney generals appear to selectively target or defend groups based on politics, they erode public confidence and provide propaganda fodder that fuels more radicalization. In the current climate, some high-level memos explicitly name political violence as a growing national threat and direct agencies to treat it with urgency and coordination. That kind of top-down clarity matters. It sets prosecutorial priorities and signals that political violence will not be tolerated, regardless of the political stripe of the victims or perpetrators, what quick and harsh means in practice. So what does quick and harsh mean in lawful, constitutional, effective terms? 1. Rapid investigation and interagency coordination. When violence is suspected, local police, state AGs, the FBI, and federal prosecutors should coordinate immediately, share intelligence, preserve evidence, and prioritize arrests when probable cause exists. 2. Use the right charges, pursue the full array of applicable charges, conspiracy, weapons offenses, arson, terrorism enhancements, obstruction, or racketeering, where supported by facts. Tough, appropriate charges increase deterrence. 3rd, public transparency. Officials should explain what they're doing and why. Transparency about evidence thresholds and legal standards helps public understanding and reduces conspiracy theories. 4. Swift prosecution timelines. While respecting due process, prosecutors should minimize unnecessary delays, keeping cases moving, particularly where ongoing danger exists. 5. Consistent sentencing posture. Where statutes call for serious penalties, seek sentences that reflect the risk and actual harm, so the punishment fits the crime and deters future actors. Quick and harsh, not vindictive, proportional but firm, addressing civil liberties and the need for guardrails. Some listeners will worry, doesn't stronger enforcement risk trampling civil liberties? The short answer, no, if done correctly. The Brandenburg framework and other constitutional protections remain in force. Prosecutors still must prove intent, imminence, and conduct beyond protected advocacy. Evidence must be obtained legally. Judges and juries remain the final safeguard. But guarding civil liberties doesn't require paralysis. It requires careful investigation, evidence-based charges, honest public explanation, and robust oversight. That's the rule of law approach, not political retribution, not summary punishment. Clear recommendations for AGs and law enforcement. I'll end with 5 concrete recommendations for attorneys general and law enforcement leaders. 1. Prioritize interjurisdictional task forces focused on politically motivated violent threats. 2. Invest in digital forensics and community reporting channels so early warning signs are captured. 3. Apply charges consistently across ideologies to maintain legitimacy. 4. Communicate clearly to the public about outcomes of investigations and the legal rationale for prosecutions. 5. Support witness protection and victim services to take the human toll seriously and encourage cooperation. Do that, and you both protect citizens and preserve constitutional norms. My final thoughts. Political violence is an assault on all of us. It doesn't matter who commits it or which cause it claims to champion. When violence enters politics, democracy loses. We need law, not lawlessness, investigation, not impunity, and justice, not revenge. Federal and state prosecutors have the tools and responsibility, and the public deserves swift, impartial enforcement. I hope today's episode made the case. Quick and firm action preserves freedom. Thanks for listening to 2 Cents Unfiltered. I'm Carrie. See you next episode.